Let's go ahead and call the study session of the YCCD Board of Trustees into session for Tuesday, June 19, 2018. If I could all please get you to rise for the Pledge of Allegiance. Ready? Begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, thank you. Moving on now to item 1.3, public comment. Any member of the audience wish to comment on any items that are not on the posted agenda? Okay, seeing none. We're going to take an item out of order. We're going to do item 2.2 first, which is entitled Investigations, Procedure, and Process.
You got it. Thanks, Jeff. Yeah, they do. They have color copies. Yeah. Thank you, Lloyd. Okay, good morning, everyone. We're going to talk today about the process for workplace investigations from notification up to the point of discipline or pre-discipline, and Meredith will take over from there on the due process materials for today. So what triggers an investigation? Well, any type of complaint, harassment, discrimination, retaliation perhaps, misconduct, theft, any policy violation. And if we get an attorney demand letter, we would start an investigation or a review on that. Sometimes OSHA, safety, workplace injuries, accidents, whistleblower complaints or reports. And then, of course, if we receive a lawsuit from someone or an administrative claim, we also would start some fact finding. So what constitutes a complaint? The easy ones to recognize: written and verbal communication from an individual specifically complaining about some type of harassment or other objectionable conduct. So the individual can verbally state that he or she has been treated badly. There also might be a report that an inappropriate act has occurred, but it doesn't necessarily have to be in writing. So a supervisor can't say, well, put that in writing and then it'll be a complaint. That's not true. If somebody receives a verbal complaint, they have a duty to bring that forward, and we start a fact-finding process on that as well. So things that are definitely harder to recognize are statements like, oh, I'm really fed up with this, or an offhanded comment from an individual to a supervisor about some maybe inappropriate conduct, but nothing really specific. You know, like so-and-so is acting strange in this way and it causes me, you know, concern. So we do a lot of work around see something, say something, and we encourage that. But sometimes you don't get a specific complaint. You just get a lot of, we say sometimes where there's smoke, there could be fire. So we get a lot of smoke and we have to run that down and figure out what's going on. Or an employee might mention something like, you know, Jeff and Jill have really been at each other today, or just a lot of workplace conflicts. So there's no magic words. We don't require employees say, I'm complaining, I'm complaining. The supervisors have to use some judgment and figure out, is this something that I should be moving forward? And we encourage them to do that. Contact HR, contact EEO, civil rights, Title IX, security, whatever the case may be.
So hang on. Are you saying that these three examples will require an investigation?
So let's be careful with the word investigation. It requires a supervisor to do some due diligence and use some common sense and figure out if there's something going on and anything to be causing us concern. So why do we have to investigate? Well, federal and state harassment, discrimination, safety, whistleblower laws, we have so many laws, it's difficult really to keep track of them all. There's layer upon layer and act upon act, and we have federal laws and state chancellor office requirements. So we have a lot of obligation to act and to investigate employee-related complaints and figure out what our defenses could be and how we can mitigate the conduct. This can include off-duty conduct. So somebody doing something inappropriate off-duty that we have a nexus to the college, we have an obligation to take a look at that. And then a failure to promptly investigate could be used as a separate basis of liability. So we could be accused of acting with malice or deliberate indifference and simply just not acting because we don't want to, or we don't have the time, or we don't have the resources. So we have an obligation to at least do an inquiry.
Can you give me an example of off-duty conduct that you would be obligated to investigate?
Yeah, so let's say an employee is dealing drugs out of their vehicle, but it's well known throughout campus, and the vehicle may not be on campus. Maybe it's parked down on, I don't know, Stoddard Avenue, 3 blocks away. But we know there's a steady stream of student traffic going by, and that's our employee, and we know it. We have an obligation because they are trafficking drugs through our college. Another example could be a porn site run by an employee, and it may or may not happen that they're uploading their videos at work, but that is conduct that is really unbecoming. And front page above the fold, MJC or Columbia College or YCCD employee trafficking porn, we've got to look into that and make sure, see what's going on. And then we also have an obligation to provide a safe work environment. It is the right thing to do to take a look at objectionable conduct or conduct that is inappropriate or could potentially violate some law, policy of the state or federal nature, and provide that environment so employees feel free to come forward with their concerns. So we initiate the investigation. We do a preliminary inquiry. Is there reasonable cause to believe that a policy violation or other wrongful behavior occurred? So we ask again that people exercise some common sense, some good judgment. 2 employees go at it in the copy room over something that happened 3 years ago in a committee meeting, but somebody walks out of that meeting feeling unsettled or uneasy or really threatened. Well, we have to look into that. It happened. It happened on our premises. Those are our employees. We have an obligation to provide the safe environment. Now, does that mean that we launch a full-blown investigation? No, we ask the supervisor to do that initial inquiry. I often use the word triage. I use that a lot. Or in the Title IX world, we adopted doing the little I, the inquiry, before you go to a full-blown investigation. So this is where we have to sort of look into matters to determine if there's anything in there to justify a full-blown investigation, or is maybe just some counseling needed, some mediation between the employees. Maybe it's a matter of retraining. They're not doing something correctly that's an unsafe condition. So there's a lot of avenues before we get to an investigation.
Is there some definition somewhere of how you define safe? Is it based on the subjective feelings of somebody who overhears something? Or, I mean, that word can mean so many different things to so many different people.
Yeah, it's like anything else. It ends up being, judge-made law or case-made law. Would a reasonable person walking in their shoes feel like this was an unsafe condition? And the courts have spent, thousands of hours and millions of dollars defining who and what and why the reasonable person is, and it's a constantly fluid standard. So you just kind of have to go with your best inference based on what's before you. So if the full investigation is to be conducted, then we send a notice of investigation to the accused employee describing the nature and scope. And we work with the union on that. We copy them so that they have an idea, because oftentimes, I'll get to the next slide, they want to bring a union rep. But I think this is important to note. Straight out of the Department of Fair Employment and Housing Workplace Harassment Guide for Employers. So the state is telling us that this is how it's done. The accused party is entitled to know that the allegations being made against him or her. However, it is good investigatory process to reveal the allegations during the interview rather than before the interview takes place. Due process, and Meredith can touch on this, does not require showing the accused party a written complaint. Rather, it means making the allegations clear and getting a clear response, and that is done in the questioning in the interview.
I have some concerns with this because one of the things that the board has indicated is that we do not want to do the minimum required, that we want to provide the maximum that we can without putting us in, financial jeopardy. And, describing the nature and scope of the allegations, why can't they see the complaint? That's what I would like to see. They need to know what they're accused of.
Well, we have a case that's currently before the Public Employee Relations Board, so that'll be a few months out, and we'll let them weigh in. If your board as a whole would like to make a change to that practice, then we would need some policy direction in writing from your whole board. That's something that you all would need to vote on.
I understand that, and I know that, and the whole board has indicated that they're interested in. I didn't finish my sentence, Gina. I didn't say the whole board agreed to giving a copy of the complaint, but the whole board at a board meeting did agree that we want to pursue and learning how we can provide more due process for everyone.
That's exactly why we're here today. We're going through the process, and then you're going to learn more about if there are other things you would like to do in addition to that.
I heard you say something about this is what the state wants, but when I'm looking at that fourth bullet point, I don't see requirement. I see good investigatory process, not even best practice, but good investigatory process to reveal the allegations during the interview rather than before the interview takes place. I heard you say something about what the state wants. Are you suggesting the state requires to do it that way?
I didn't say that, no.
All right. I did hear what the state wants, so thanks for clarifying.
Although this did come directly from their handbook, so presumptively somebody wouldn't put something out there unless they wanted you to do it.
I do not accept that because the state, that is written by capable professionals who would say requirement when they meant it.
Fair enough. So the purpose of investigation, it's an impartial fact-finding, and it's to reveal or exonerate employee misconduct. So we get a lot of complaints, and some of them people never hear about. The employee doesn't even hear about because we do the triage or the due diligence ahead of time and determine that there's absolutely nothing there. And why would we even go forward with that and bother the employee or the supervisor and take up time and resources? So that's part of the iterative process of doing an investigation. And then as we work through the investigation, we determine based on the preponderance of the evidence whether or not a policy violation or the wrongful behavior took place. We provide the factual basis for any disciplinary action. So the purpose of the investigation report is to provide a factual statement of what happened, and then also to look at an opportunity for further wrongdoing, because the investigation often details some inappropriate behavior. And then we have an opportunity to take some mitigating interim measures, whether it be separate employees or change work shifts or stop an unsafe condition. We have an opportunity to do that as it unfolds during the investigation.
I need a clarification, please, on number 2, the second bullet point, reveal or exonerate the employee misconduct. Is it the practice of this district that when they get a complaint, they do the exploration and they do the fact-finding before they notify the employee that somebody is accusing you of something?
Yes, that can happen.
So can happen, or is that our policy that we, so I mean, would you go to an employee and say, hey, somebody filed a complaint about you, but I'm not going to tell you what it is because we haven't investigated? That wouldn't happen.
Do you know otherwise? Well, excuse me, your body language indicates to me that maybe that's not the case.
That is not the case, yes.
Okay. So if you have a specific example, perhaps you'd like to share that with the chancellor, and then we can figure out the process and maybe what happened in that particular instance.
Be happy to.
Yeah, let me get this. There we go. No, this is just a basic investigative process where they get the copy of the complaint as if charges attach, and Meredith will go into that. Once we complete an investigation, and then if we determine misconduct occurred, and those are in some further slides, we present the copies of all the evidence, the complaint, the reports, everything that we have gets turned over. Yeah, so the challenge is that Title IX has some very specific requirements, which of course, we got a lot of guidance from the US Department of Education in their Dear Colleague letter. And then that changed and they said, don't do anything with the guidance right now. We're redrafting the guidance. So this world is constantly in flux, and I don't know if Meredith made it. Yeah. Hello, here you are. So, and Meredith, can certainly attest to this, Trustee Rojas, but Title IX has different requirements, Ed Code has different requirements, whistleblower has different requirements. There's all of these competing acts and laws that work together that tell you what process attaches when, and that's what we try to navigate and work through.
Make it a lot easier.
And you certainly, as a board can. Sure, absolutely. Okay, so investigative steps. We would develop an investigative plan and then conduct a thorough interview with the complaining party. So regardless of how the information came to us, whether it be written or verbal, or maybe there is no complaint per se, it was the fed up statement, or John and Jill are at each other's throats, we would then do interviews. We would interview all relevant witnesses and review the documents as well. So there can be documentation in the particular case. And then we'd give the accused party a chance to tell his or her side of the story. And this is where we present the allegations after we've done some initial fact-finding and done some of those interviews, and lay out what we know so that then they can tell us what they know and what their responses are to that. And so this is where the business of not showing the complaint ahead of time, because you give somebody the complaint and then they want to run off and do something with it. They want to confront the employee. They want to take action. They want to defend themselves, and rightfully so, but it's a little early in the process to do that. So it's just, it's a difference. And then a lot of times they go out and find other witnesses that to corroborate or make up a story. So really, they're not helping themselves by running out and trying to do that in advance. So that's part of why we don't show the complaint ahead of time. You want to try to elicit as truthful initial responses as you can, not something that was planned or rehearsed or thought up of, or you're not putting on a court case at this point. You're just answering some questions. You're answering some questions.
I think one concern I have, and I understand why you want to wait to let people know what's going on, but that puts you at such an advantage because I think people tend to panic when they're hit with something, and they may say, they're not as careful with their words. Maybe they may say something that could get them in trouble later, which isn't really true. I mean, it's very difficult to be fair. And I think that's what I'm concerned with, is being fair. And you take as much time as you need to put your case together, and then somebody is like hit with something and they're totally caught off guard.
So let's reframe the discussion. We're not putting together a case. We're just fact finding. We're trying to find out what happened. And a good many of our cases, and Lloyd and John and anybody else who's done an employee investigation can attest that a lot of stuff that we fact find isn't true. And we close the case and never have to burden or bother or upset the employee with it in the first place. That is our job.
I have a question too, but I can go after Alan.
Okay. To suggest that these meetings can't become adversarial is contrary to fact, number one. Number two, we're not impugning anyone's professionalism. That's not the idea. But to say that, don't worry, everybody conducting one of these meetings will remain aware that it's just an investigation, it's not accusational, et cetera, et cetera. Really, that's quite a claim. Also, to suggest that it's a matter of finding the truth, to blindside someone with an allegation, and that's how the truth will come out. I guess we're talking about lie detecting or something. I wonder about the theory behind that. And if you want the truth to come out, it seems to me that you need more than one side of a disputed issue. Instead of suddenly someone who's already in a tremendous amount of stress, maybe never been in trouble before, doesn't know what's going on, and is suddenly confronted with an allegation that could result in termination or other damage, long-term damage to the person, because it's that serious sometime, and suggest that's about getting the truth, I'm stymied, unless you're talking about lie detecting. And to suggest that faculty will run around and get people to make up lies and allegations, I would suggest to you that the YFA has a very strong investment in nothing like that happening. I don't know of anything like that ever happening, and yet seems to be the rationale for a very questionable procedure.
I'm sorry, you don't know anything like what happening? I'm not clear on your statement.
Of people running around, having other people help them fabricate lies, et cetera, et cetera.
It has in fact happened at this
Well, I will say this, the YFA has a very deep, the YSA has a very strong investment in nothing like that happening, but
As do we.
okay. Now, it seems to me, in view of this mutual concern, that suddenly, in the middle of this very stressful procedure, which the respondent may not really understand, suddenly confronting someone with allegations and then saying, the person may not remember the incident, right? The person may, and again, the YFA is not suggesting, for example, that a name be named of the accuser and so on. That's not the point, right? The YFA definitely wants a sense of what evidence is being used, what is the reasoning and the evidence about this allegation and the particular allegation, so they can respond to it. The individual would sure like the same thing. Now, that doesn't mean necessarily, although other people would disagree, that you necessarily name a name of the accuser or whatever. But the respondent can be flabbergasted, like, what are we even talking about?
And that tells us a lot. Tells us a lot right there.
I am really questioning that whole
They are
approach.
flabbergasted. The investigator goes, they didn't have a clue what this was about. And that goes towards their credibility.
So,
They're shocked.
so the investigator will read the nonverbal, take it into consideration, and this is, make some judgment on it, and that's truth finding.
That's part of what. Okay. Okay, so employees have the right to the union representative that be present during an interview that may lead to discipline. That's under Weingarten, and all of our employees avail themselves of that opportunity.
Does that apply to classified?
Yes, yes.
Okay, what about part-time?
Permanent, part-time, hourly, if you have a permanent right, but typically our other folks are at will. So they would not be represented by a classified union at that point. Our short-term contracts are not. So although we don't have an affirmative obligation to inform the employee of their right to representative, our notice does say that, and we typically have a relationship with the union representatives where we try to schedule the meetings and the discussions at a mutually agreeable time. We really work to do that. The employee does not have a right to a representative of his or her choosing. For example, I want Perry Mason, but he's not available for 2 months, so we don't postpone the investigation just because Perry Mason can't be there. There are other trained union representatives, and doesn't necessarily have to be a union representative, although a lot of times they are the person, but I've had employees bring their spouse, their attorney, their pastor, their best friend, so it's just a representative to attend the meeting with you. And then each union has their own requirements on if an attorney's involved, whether or not they'll continue to participate or be in the room or not.
Okay, I'd like to ask on the second bullet point, it states that the employer is not required to inform them that they have a right to a representative. I'd like us to go beyond the requirement and tell them. What's wrong with that?
And we,
I agree.
although we do in the notice of investigation, so we tell them,
How about
you can bring a representative.
in the interview? And how much time do you give them to find someone to bring? Particularly those not involved with union representation.
Yeah, typically 3 to 5 days. It's not be here at 1 o'clock and you're going to answer questions. So we give them ample time. Sometimes they want to arrange for their.
I wouldn't call 3 days ample.
I wouldn't either.
Well, we work closely with the unions, and there's generally somebody available.
Okay, but I'm talking there are people that do not have unions that for them 3 days may not be ample time to find someone to come with them.
Well, then they need to tell us, I don't have a representative, and we ask them to, help us understand and what's going on. And they may say, well, I want to bring my attorney, but he or she's in trial and is available on June 29th. And we say, okay, we can work with that. So we do work with people.
Okay. A trustee, Abe, or a trustee, or perhaps someone who's, she described, I don't remember, in leadership, they don't have a union. Anyone in leadership? Leadership, anybody in the LTAC.
Right, but remember, LTAC are at-will employees. Yeah.
They still have the right to
They do, but they're a little different animal in terms of employee representation. They're not really represented employees. They are an advisory council. So, yeah, but typically if we need to interview an at-will employee, they just come.
Also, students and volunteers, docents, they don't have a union.
So the employee cannot refuse to answer questions or wait for the chosen representative, such as a private attorney, to show up, but we typically don't have that issue. But if there's a urgency or an exigency and we need to ask questions and get moving, then we proceed with that questioning. I can't think, though, of an instance where we've had to do that. We typically work with the representatives and getting somebody here to support them. So once all the interviews are complete, we have collected the evidence, we document it in an investigative report. There is the credibility assessment, as you mentioned, is completed for each person interviewed. And then a thorough review of all the statements and evidence is conducted. And then a determination is made on a preponderance of the evidence standard, whether or not there was a policy violation or other wrongful behavior occurred. So the investigator writes his or her reports and findings, then presents that to the employee's manager. And as the manager hiring authority, that would be the individual who would be recommending discipline. So typically that's a dean, a vice president, a director, and above. So we would draft a disciplinary notice and attach the full investigative report along with all the witness statements and other evidence that we have, whether it be photographs or copies of documents, anything at all, videos. And then they receive a notice of proposed disciplinary action. Now, note it's proposed, so nothing has taken a final effect yet. And we have to lay out all the reasons. And then, as I mentioned, a copy of the charges and all the materials go along with that, along with the statement that they have a right to respond either orally or in writing to the employer within the time specified for this. And this is what we call the Skelly Conference. So this is another opportunity now for the employee to talk about what happened, what the case said. But just real quickly, the employee's manager, when they make the determination of any disciplinary action, this is really when the due process rights come into play. And you may recall that the process that is due to you depends on your classification, standing, category. So different groups have different process that is due to them. And there's quite a bit of disagreement or discussion. That's part of the reason why we're here, is educating and learning and thinking and talking about what process would be due to each group across the district. So as it stands right now under state law, those that have the Skelly and the due process are those with a permanent position. So they have a property right to their position. So that would be your tenured faculty. That would be your classified employees who are not on probation. But everybody else has different types of process that are due to them that don't involve a property right to their position. And Meredith will get into that a little bit later. So these are just some of the...
I just real quick, let's go back to that for a minute. And I want to get to sort of the meat of this, to the heart of it real quick, because I may have to leave. I got a project I'm in the middle of, and I apologize for that. As we've navigated this whole issue of, quote, due process, I think there is some confusion on both sides of the aisle as to what that means. What is due process defined? Excuse me. What is it that we're trying to accomplish? And I think you just sort of touched on it when you said, well, there are different groups based on their classification. This is what we are going to afford them. And you mentioned property rights. For me, I see this as really coming up with a framework of guiding principles of how we would like to treat all of our employees or volunteers. I don't think anywhere in a guiding principle document per se that we're going to extend property rights to those that are not entitled to it. And I'll give you an example. When I did internal affairs investigations at the Sheriff's Department, we handled all employees the same. I can remember doing investigations on at-will reserve part-time deputies because that's what Sheriff Weidman wanted to do. Now, in the end, you know, the sheriff or the assistant sheriff would still sit down with those individuals for a Skelly hearing and just wanted to hear what they had to say. But it didn't afford them a property right to their job. They were still at-will employees. And in the end, if the recommendation was to terminate, that's what happened, because those individuals did not have property rights to those positions. So I think for me anyway, I think that we can come up with some sort of framework of guiding principles that says this is how we want to treat all of our employees, and we're not extending property rights to those individuals that are not entitled to it. Because I agree with you, we don't want to find ourselves in that situation. But I think we can take a step back and still come up with some sort of guiding principle document that we want to treat all of our employees the same way. And that's all I have to say on it.
I do too.
I'll let Meredith get into those specifics and what would and would not attach at what point in time and what that looks like.
I'd like a clarification on one bullet point on the previous page, just so I understand this. It says, the third bullet point, a copy of the charges and materials, the investigative report on which the disciplinary action is based. So any employee covered by a union or not would receive a copy of all the charges and all the accusations, and they would know who filed the charges at this time?
Yes.
Okay, but only if we get to the point of completing an investigation and wanting to bring disciplinary action.
Correct.
Okay, thank you.
Okay, so just briefly, Skelly or a form, often in HR we call this the Skelly or due process rights. And again, we've learned and can certainly agree that we all have different definitions or applications of the term due process. So those are some of the underlying constitutional arguments for it. But disciplinary actions that trigger these are ones that would deprive somebody of the property right. So termination, suspension, demotion, involuntary transfer, or reassignment. And depriving someone of their job property right is loosely applied because an involuntary transfer means that their working conditions have changed. So they've gone from night shift to day shift and lost premium pay of 10% or whatever it is. So anytime you're taking something away that's tangible, like pay is kind of the big thing. If somebody's losing pay for some reason, whether it be unpaid suspension, a demotion, or a termination where you're permanently taking away their pay, that would trigger the right to the Skelly hearing, and the property right attaches. So the investigative process itself doesn't include these actions and doesn't deprive the employee of their life, liberty, or property. These rights typically don't attach until disciplinary action is determined, except in the case of forced administrative leave. And there was this new law passed, I think it's 2018, January 1, where if you're placing a faculty member on paid administrative leave, there are some processes that you have to go through. So pay is not necessarily the triggering factor there.
Just to clarify, how long do investigations usually last? Can you give me a range?
Yeah, they can be anywhere from 4 weeks to a year plus.
Give me an example of why an investigation would take over a year to complete.
We have certain employee classifications who are unavailable and can't be available for witness interviews during the months of May through August. So that takes you 4 months we don't call faculty members in on the summer unless they want to be here to answer charges of investigation. They just don't want to come.
And while this investigation is going on, the person who is being investigated knows that there's an investigation going on, right?
It depends. If we have served them notice that we need to talk to them and to bring their union rep, then yes, they know it's going on. But we have had faculty say, well, my contract ended at graduation, so I'm not available, and I'll see you again on Institute Day. And we have had a practice in this district of honoring that.
Okay.
In that effort, we're trying to accommodate them.
We're trying to accommodate, yeah.
In that instance, just back out the time delay as requested, and, you know, the time becomes semantics at that point,
Yeah.
really.
Other instances for taking a year or more could be, there could be a companion court case, something going through the judicial system that also involves conduct here or impacts conduct here. So you have to wait for things to play out in the court system. So it runs the gamut. So,
I was just expressing concern because even though it may not technically deprive them of life, liberty, or property, it's certainly an investigation that goes on that long is going to cause a great deal of stress.
I agree, along for our staff that have to conduct the investigation and are trying desperately to wrap things up. But when people aren't available or don't want to come, then we don't have a lot of choice there. So after the employee receives the notice of intended discipline, then they get to respond, as I said, orally or in writing. Oftentimes they will request to have the Skelly conference. And a Skelly officer is generally an executive level person. So we would use VPIs, presidents, vice chancellors to be the Skelly officers. They read through the allegations, all the supporting documents, and then have a conference with the employee. And they get to respond about, you know, their mitigating factors and tell their side once again to the Skelly officer. And then the Skelly officer makes one of two determinations. There are reasonable grounds to proceed, or the proposed discipline should be modified or revoked. So basically, that's their decision, one way or the other.
Can the Skelly officer that's selected have been involved with gathering evidence? Does it need to be a neutral party, or should it be?
It does not need to be a neutral party. A president can hear a case of their own college. A VPI could hear a case in their own division. But we have had requests and honored them to have somebody else outside or the sister college president hear the case that might have happened at Columbia would be heard by MJC and vice versa. Or we have had things that have happened in instruction and a different VP in another division has heard it, but there's no requirement that they be not in the division. So again, the Skelly officer determines if there's reasonable grounds, and then the Skelly officer will make that report back to HR, let us know of their findings, and then we assist in preparing the final notice of discipline. So they had the proposed, they had the Skelly, and now we have the notice of discipline that says that they were offered the Skelly conference, the date it took place, and then the recommendation of the Skelly officer. Then we include the appeal rights that are outlined in the collective bargaining agreements. And those include common forms or arbitration, a hearing officer, or a board hearing if they request. And I don't know the last time we've had a board hearing. I know we've had a couple come close where you've had to do some consideration in closed session before we had a hearing requested. But since I've been here, we haven't done a board hearing. And then finally, those hearings could be subject to judicial review, and the court will evaluate whether or not the district provided employees the appropriate procedural due process. So it becomes ultimately judicial scrutiny on whether or not we provided Skelly rights and followed the procedures as outlined in the collective bargaining agreement. And the court does use their independent judgment to determine whether or not there was misconduct. So they just don't do a cursory or de novo review. They go in there and actually dig in and see if whether or not the misconduct occurred in that particular judicial review. And then they determine whether or not it's supported by the disciplinary, whether the evidence supports the disciplinary action or whether there was an abuse of discretion or process or something along those lines. And typically, as long as the facts support the allegations, the court's not going to disturb the penalty unless there was an absolute abuse of discretion. Something really went awry, some right was not afforded, or some process wasn't followed.
How does such a case come under judicial review?
The employee or the union would take it up on appeal to court.
Okay.
And then finally, included in your packet is just a flow chart that kind of walks you through the decision points. It was a lot to try to fit on one page. So rather than being a timeline continuum, we tried it and it was going to stretch about 7 feet across the room. We just kind of did the loop-de-loop on the chart there, but that will give you just a little guide to take back and see how the process works. Additional questions for me on process? All right, I'm going to hand it over then to Meredith, who's going to discuss the issues of due process and guiding, I guess perhaps guiding some guiding principles and what that looks like. Do you need PowerPoint? Okay.
And I have to apologize, I made some revisions last night and then asked my secretary to print them, and she printed the copies that I hadn't provided. So we're just getting those sorted out. But if there's a way to use the email version. And then the copies of the record in just a moment. So while we're getting those Word documents put up on the screen so everybody can see, there are copies that'll be brought to you as well. One of the things I wanted to mention at the outset is that the concerns that you raised regarding the process as it stands is the baseline that I used for developing options. Because as I recall from the due process conversation that we had earlier, what you wanted to do was look at what the current state of the law is now and what the current state of the process is now and see how you can improve on that. But at the same time, do that in a cost-effective way so that we didn't have a substantial impact to the classroom or to the general fund, because you wanted to make sure that you were able to balance the two. And I'm empathetic to that. So what I've done is put together options A through D for you to evaluate. And it's a chart that has several different iterations of different choices. We're going to now have the magic of technology, put the Word documents on the screen, and the copies will be coming to you. And I might say that I did put a lot of reflective thought into this, because what you're asking is in the vanguard. There is not another community college doing this. So looking at how to make a process that is incrementally advancing towards providing the most amount of notice, and we also, I remember being asked about the clear and convincing evidence standard, so that's in there as well. So that, it's unprecedented, and so that means that you have options A through D, because we want to take it in steps so that you guys could balance and evaluate at each stage and see what you feel is the most, hits the right tone between what you're looking for. So you get the copies. Okay, so here's the first.
What would you like up first? So you
Let's
have
do the memo first.
Okay.
And I'll talk through it. And so I'm going to scroll. I'll scroll this down a little bit so we can. Do you guys want to take a break now, or do you want me to take you through just the general overview and then the charts?
I think you can go over a general overview.
Okay. So what we've got now is just basically the introduction. And this basically says that I understand that you, as a board, are considering revising your policies. And in order to be cost effective, rather than go through each of the policies and address them and rewrite them, there's less attorney time invested in showing you the options in a chart. And I, believe it or not, I'm one attorney who doesn't want to spend a whole bunch of your money. I mean, I'm a board member too, and so there's like this DNA battle that's going on. You know, there's the attorney side, and there's the cost-conscious side. So I've made an effort to illustrate this whole thing. Once the board decides which option you want, then we would actually get into the process of the revising, and then I understand you have a shared governance process and your policies, and so I didn't want to waste your time or your money. So, and the chancellor also said, Meredith, make sure you do this in a cost-effective way, so we have the options, and so that's basically what's explained here. So the first option is going to be option A. Option A is going to tell you where the law is now. That is a reiteration, basically, of what your Vice Chancellor of HR, Ms. Liguria, has explained. It tells you really what the law says, what's the current state of the law. So that's, it looks, you compare A to each of the other options. One of the things that I point out, however, is that there is a new Ed Code section that we mentioned briefly when we were doing the due process review, which talks about before someone is put on paid leave, that at least 2 business days before, that person would be notified of the general nature of the allegation or the allegations of misconduct. Now, I thought that that was helpful and instructive because what you had said before when we first looked at this and what you're saying now is we want to know what the general nature of the allegations are. Now, when you start an investigation, all you know is the general nature. That's all the district's going to know. That's all that could be communicated. So that's why it says general nature of the allegations. That's a starting point. What I hear you saying is, what about sharing what you know at the time? You're not saying don't investigate and don't go through the disciplinary process. You're saying, let me know what you know so that when we have a conversation, we have a common understanding. So I thought that 87-623 was helpful because the legislature has already invested time in coming up with the language that's explained in the statute. So I have written the statute out for a reference, and I'm not going to exactly go through it now because the copies are being printed, but I wanted to give sort of a backdrop. Then we'll go through option B, and that's the right to be informed of charges and the opportunity to refute them. This also, I had done a revised copy that had fiscal impact on it, and I don't see that on this one. Oh, actually, no, it's on the option. It should be on this one, actually. So option A has no fiscal impact. Option A is the current state of the law. Costs stay as they are. Option B is going to have a cost impact because this means that we have the right to be informed of charges and an opportunity to refute them, which means that you're going to actually, members of the community could refute charges against them through submission of written material or an informal meeting, but you're going to have to put a little bit more into the infrastructure in order to accommodate this process. And in the chart, there is an estimate of attorney hours and staff hours so that you know what the estimated cost would be. And that is based upon the general market rate per hour of attorneys and generally how much time it takes to go through the process.
Meredith, could you explain how option B is different and might add expense compared to option A? I'm a little confused on that.
Yeah, well, and it's also, the chart illustrates it a little bit better.
Oh, okay.
You'll be getting that handout in a minute, which is easier to follow. But what you'll see in option B is that where there is a existing right for a hearing on option B, then there would be, number one, you'd be informed of the general nature of the charges. As soon as the district knows, you know. That would be the change. And then there would also be an informal hearing that would then allow there to be an opportunity for the person who is the accused or the person who the investigation is about would be able to have have a meeting and provide their information, and the district would provide its information. That's a little bit more involved than the process that you already have, and so it's going to have a cost impact. And that cost impact would be the amount of time together to do the investigation and gather the witnesses, or investigate to interview the witnesses, to gather the documentation, and then to get a hearing officer. You also have to hire the hearing officer. That'd be in addition to the cost of a formal hearing. And that cost, we estimated, would be maybe $3,000 to $5,000 for the hearing officer. And then the attorney cost would probably be about $22,000, because you'd have to go through the interview process of all the witnesses. You'd have to go through the document review process, gathering the documents, and then you'd have to have the supervisor. If the person had a supervisor, that means if they were a volunteer or an employee, that person would have to sit through the hearing. You'd also, and if there was a employee, of course, that the supervisor would be there. And then you'd also have the staff time that it takes to do the copying.
We don't ever have in-house hearing officers?
Part of the law regarding the hearings is that it's fair and impartial. So what happens sometimes is if you have a person that's employed by the entity that is doing the hearing, you want to get somebody that's in a different department, or I've seen that done in some cities, or you want to get somebody on a panel. So what often happens is you get a panel of hearing officers because you want impartiality and someone who is not dependent upon the institution for their employment or for their compensation, other than just as a hearing officer. What happens sometimes is that a city will get a panel of attorneys that are licensed to practice that are in the area that are on call or approved by the panel as hearing officers. So that's why in most instances, you pay the hearing officer. You don't want there to be a conflict of interest with the hearing officer.
So what I hear you saying is that when we do it in-house, it isn't impartial.
There are cities that do it in-house, and there are cities that don't. And oftentimes, if the case law that evaluates whether or not there's an impartiality it goes to whether or not the person is in a direct reporting relationship, or if they're in a different department. Say if you're going to do traffic violations or planning violations, you get someone in a different department that would be the hearing officer that would sit there. So there's separations and gradations of distance that the law looks at to determine whether or not it's impartial. What we presume was that you get an outside hearing officer. Gina, what's your general practice here?
We get outside hearing officers. As distinguished, though, I want to make sure that we're not talking Skelly. Skelly's completely different. The Skelly's pre-imposition of discipline. So that is done in-house. That's a Skelly conference. But if it goes to the disciplines imposed and then it goes to an appeal hearing, then it's all outside.
And so in looking at the due process options, option B presumes that you actually use an outside hearing officer at the first instance. So that's why there's a cost increase. And let me remind you, you don't have to do this. I'm just giving options for you to look at. Because this is the effort of being creative and saying, what are the stair steps? What are the different options? So in this option B, it presumes that you're going to use an outside hearing officer, not somebody in-house, so there would be an extra cost. If you guys wanted to look at the options and modify them to decrease the cost, you could do that as well.
Also, you're not taking into account that if we could go with the cheapest option, which you said doesn't have any added cost with A, but then you could get sued. And you could end up...
You wouldn't increase your exposure to liability if you went with A any more than you already have.
You would not.
You wouldn't, because option A is how you do things now, and it's the current state of the law. Options B through D are the effort to bridge the gap between what you have now and what I understand your desires to provide greater due process are.
Okay.
Speak into the mic, please.
What you're looking at is what in the current state of the law, when you get the statement of what the district knows, the district has had a chance to begin its investigation initially, even enough to know what policy it might be. Generally, what happens is somebody's going to come to you and they say something like, there's a hostile work environment, and so you're going to go through it. Or they're not even going to use that language, actually. They're probably going to say, I feel bad, I feel uncomfortable. The district would have to look through its policies. So there's going to be a general nature, which means that maybe not all of the policies, you're going to know what the district knows. You're going to know what the district knows before the investigation starts. And so what the district knows, presuming we go with option B, it means let's start with an even board. You know what I know. And sometimes when you do the investigation or when you do a little bit more looking into the issue, you know a little bit more. You find out, oh, well, this policy has been violated. I didn't know that because I hadn't talked to that witness or that witness. So it's very general. And that shows, in a way, it shows how much the district doesn't know when it starts out, and how someone comes to you and says something, and then you have to try and figure out how it fits in the framework of case law and statute and your policy.
Meredith, can I ask you a quick question? And my apologies, maybe I wasn't following along as well as I should have. Where did the idea of hearing officer come from in option B? So we're talking after everything's over?
Option B presumes at the outset, the district just gets someone to come, someone comes and says, and gives a complaint, or says, and by complaint I mean oral, may not have even written it out. And then what if you went from that point of being told there's something wrong to the process of going through all of the investigation and getting all of the information? What process would you use? So we presume that we're using an outside hearing officer because that is what the Yosemite Community College District does in their more advanced situations. And so it's a factor that we put into this one so that you could look at it and evaluate it. It's separate, when you see the chart, it's separate from the attorney cost. So
Right. I get the attorney costs as far as if we want to implement any changes and making sure we're covering all of our bases. I need to get going because I'm sure some people here can relate. When you undertake a project, it doesn't always go as smooth as it should. But before I go, I want to go back to this one slide that Gina put together, the entitled "What are Skelly or quote due process end quote rights" with a question mark. For me, I think if we started off there with our guiding principles for all employees, including part-time adjunct and volunteers, and just said, this is how we're going to start the framework. Abe, is that kind of, I mean, if we just said, this is how we as a district want to treat all of our employees, but clearly understand that in there, that if you're a, volunteer, if you're a part-time or you're, management, or we're not changing your classification. We're not affording you, as Gina pointed out, we're not affording you anything as far as property rights or extra rights that pertain to your particular classification. So if you're an adjunct at will, you're still an adjunct at will. So if you go through the Skelly process, for example, and the Skelly officer says, I have painstakingly reviewed, I've sat down with the accused party, and I believe that the charging document is true and correct, and that I'm sustaining the recommendation for termination. There you go. So rather than get into all of this down into the weeds, so to speak, for me, I think we need to have just establish a guiding principle document and move on, and then just ask a question real quick. At what how many investigations do we handle in-house? How many are we shipping out to private counsel? And I ask this because I see, purchase orders all the time for all of these different legal firms for human resource. So I just want to get an idea. Do we have enough talent in-house to handle these, or does it get to a certain level where we say we're shipping it off because in my world, we did most of our stuff was all in-house.
Correct. We have the in-house talent. We don't have the time. The individuals who are tasked with doing these have other jobs. This is an other duty as assigned for them. So if you want to instead allocate resources to a full-time in-house investigator, that could be one option. But ultimately, when the disciplinary notice is drafted, we do not have the in-house scrutiny and review. We have to ship that out to an outside attorney who specializes in the ed code, because or use whatever attorney we have on retainer for that particular matter. But all the disciplinary notices do get reviewed by an outside attorney.
Okay, seems like
Cost already.
yeah, I know, to me, I don't know, it's,
So Chair Garrett,
Different
before you
world.
leave, I wanted to just point out that B, if you combine B and some of C, that's exactly what you get. What I did with B was I just added more detail with regard to the notice. What I did with C is gave everybody the informal hearing that is a Skelly hearing, basically. So that, and these are puzzle pieces. If you want to take or move, that's why they're line items. Because what what I would like to provide to you is a framework that can be modified so that you have what you want and that you could be cost-effective in implementing it, because it hasn't been done before. It means that you're going to need an estimate of what it's going to cost, because we can't look to anyone else. And so we have to look at what you already do and say, how many more hours is it going to require? As Gina mentioned, that there would be the new talent. You could evaluate a full-time investigator versus these other costs. But I had to give you something, some basis to make a evaluation. So that's what this attempt is. So it's not a cut and set in stone, this is how it has to be. It's, here are the line items, here are the different ways we could do it, and if you want to move some of them around, then that's a possibility too, but at least they have the costs associated, so that when you're putting the beads together, they have, what the weight of the beads are, what the impact, the fiscal impact is.
So it would be good if we could see how much we're spending on the out-of-house investigations. What was it, like 15,000 last month in the purchase orders? I think it was something like that and it said HR.
Yeah, but those aren't all investigations. Some of that is attorney time on disciplinary notices or old cases that we have. So let's not mix up litigation with investigations.
Okay.
Yeah, don't make an assumption that every purchase order is attached to an investigation. Those could be pending litigation, and we have quite a few cases going through the courts right now.
Right. No, I was just saying that for comparison purposes, if you talk about an in-house investigator, we'd have to compare what we're outsourcing and what we would do in-source.
We haven't outsourced one in quite a while because the last outsource bill that we got was for $21,000, and that seemed excessive, and that's not an expense that our budget could afford, so we opted to do some in-house, but unfortunately the volume now doing them in-house and the time that it's taking is taking up all of several people's jobs, and they're not doing their regular work. So we're paying either one way or the other.
so Gina, I would support whatever, because you and I dealt with these in our earlier iteration of our lives and careers. So whatever if you have ideas or thoughts that you think would improve or maybe not, I would love for you to entertain those thoughts and ideas, because for me, I think you maybe get a better product if some of them or more of them are done in-house. So if that means we need to send some of our LTAC folks off and get some training so they can do more of these, I don't know. I'd support you either way. That's where I'm coming from. So you've heard enough. I need to go. So thank you all very much.
You know, just a thought, at what point, we're getting all this training as a board and few people that are here, but at what point does faculty, staff, volunteer, part-time, whatever it is, at what point do they get to understand all this information that we're getting? I mean, it seems that they won't have that knowledge until there are actually charges being brought against or thought about being against.
So your policies have a shared governance process, which means that your policies would go through the evaluation of the district's, the combined review process. I'm sure you have an academic senate and a classified senate representative, and you have your administrators that look at policies. And I'm saying this from looking at your website, but there's a shared governance process that reviews policies, and they have a first and second reading. This would be quite a bit of work also and so that's another reason why putting it in a chart and giving it to the board so that there could be an effort to whittle down the information so that you know what you want to go on to the next process so that it's not absorbing so much of time. Not to say that your time is not valuable, but if we were to do this at the large scale of your shared governance, it would take up a lot of time, and there's a lot of other work that you guys are doing. So I'm trying to provide the options and the costs in this forum so that when you find something that comes close to what you want and it meets the balance, then you could say, okay, this is worthy of taking to the next step. Now we could have these broader discussions before it gets to the policy revision, because that's a very involved step as well. And we don't want to expend the capital, put the money into it until you know what you want to do.
The reason I ask that, because I'm on campus a lot, and people ask me people can bring charges against me. We're being told that people can bring charges against me, and we won't even know about it. So a lot of people on the ground, faculty, staff, don't really, to me, don't understand what would happen, other than the fear that they're going to be charged and prosecuted and whatever else there is that goes with it. And so that's my concern, is that, how do you get the information out to the people on the ground, per se, that these are the policies that are available to them, policies and procedures.
Well, these are options, right? So what I've got
I
here is,
understand that. I understand where you're coming from. I'm just saying, to me,
If I could answer, our employees are pretty well informed. They know what their rights are. Their unions do a great job of communicating that to me. I know faculty have some, they used to have the 10+1 cards, and I don't know what YFA puts out anymore, but people know who to call, or if they always call their union first, usually. That's been my experience. CSEA has chapter meetings. They go over policy changes with their employees, and if you go in our break room over here, there's a board up there from CSEA.
I understand.
Yeah, no, you're right. So people know.
I understand all that, Gina, but there aren't people that know, that don't. There are people that don't know.
Yeah, I ran into adjuncts like that.
All over the place, but there's people that don't know, and that's the people that I want to make sure that they're treated fair in whatever the due process that's established. I'm not saying that people aren't informed, because there are some people, and the higher up the echelon you are as a dean, whatever else that goes up higher, they all know, but the people down below that are pounding the ground and sitting with the students, they're oblivious of this until something happens to them. So that's all I'm saying. I'm not being critical. I'm just saying, we go through all this training, and we know as a board, we sit here, and even some of us don't understand it, and so it's kind of sometimes I feel like it's frivolous that not that that's a bad, but I mean, it's good that we know all this, but I'm counting on staff to be able to justify whatever we do. And I guess that's where you come in and say you're trying to establish some kind of operating procedure, whether it's B or what we're doing now, so that we do have just a solid base to go out and, or to be able to tell people, here's what we're doing, we're trying to protect you, but it's built on trust and equity as far as I'm concerned, so.
Yeah, I mean, the board in its governance role would vet these charts and say, let's try this. Then people would weigh in on the policy. And Mr. Missick?
Somewhere the general, oh, wow. Is that just now kicking in?
Yep.
Yeah.
Oh, I'm sorry. The red light was on, I swear.
So
Yeah.
I hear what you're saying. You're
Yeah.
saying, how certain, how specific regarding the policies will that first notice be? And the answer is, it'll be as specific as the district knows at the time. And that's where the problem is, because as soon as the district gets the complaint, hears of the issue, and they communicate it, they're going on what limited knowledge they have at that
Surely.
time, they may miss something. And that's part of what the downside of adding more of the notice up front is. Both parties are going to be somewhat limited in their knowledge. But it's beneficial in the sense that both parties know what the other one knows.
Okay, I understand. And maybe I'm asking about option A too. So what I just heard you say is, of course, the investigation brings out, other evidence. That's what it's for, right? And it's a possibility more charges end up being brought as investigations go on. I've already said that. But the district, of course, wouldn't be interviewing the respondent unless some policy or law was at issue. So I think I just heard you say when the district is, say, informing the respondent that there's going to be an investigation, we're going to interview you, right? That, of course, there should be, it's about policy number whatever, even though more can come out later.
So let's go back to this statute. That's part of why I put this statute in here, 87623, because it says that the employee shall be provided with, at minimum, the general nature of the accusations made against him or her within 5 business days of the employee being placed on involuntary paid administrative leave. The knowledge will most likely be, almost certainly be incomplete. And one of the benefits that you have under the system as it is now is when you have the charges, when you're told of the charges, in this the Skelly hearing, or you're told of, when you have that opportunity to sit down and share information, you get a more exact statement. There's not going to be an exact statement because there's going to be limited information. That's why it says general nature. That's why the state legislature put general nature, because it's the speed in which you know that is what's carrying this statute. At least 2 business days before he or she is placed on involuntary paid administrative leave. That's the first paragraph. The second paragraph mentions in the event of a risk of serious physical danger. So, say you get a terrorist off warning, right? And somebody says somebody's dangerous, somebody had a psychotic break, you know, you get one of those, you have to hurry up with the leave. So you're not going to know everything. Or somebody says, I was threatened. Or if there's a serious risk of injury, then there's a need to move quickly, but you don't want to have that abused. You don't
Of course.
Right.
So that's why you have 5 days. Basically, the legislature is weighing the sharing of information at the outset versus the exigent circumstances of there being physical danger. And so when we're talking about giving the general nature, we're saying we're going to share the information, but it's not going to be complete. It's going to be somewhat.
Okay, does the general nature, now, I heard you reference Skelly here, at the point of the scale, at Skelly, right? I've also heard you reference, well, can go to court and all that. Now, and these things require very specific statement, okay, these are the charges, right? I'm talking back during the initial investigation. I'm talking back at when the person was brought in for interviews, okay?
And I'm talking about
Oh, I know.
when you first get the first one.
Okay,
But
The sooner you hear, the less complete the information.
granted,
so
but
don't we just say that up front? This is what we know so far. It could change.
That's why it's general nature. But I understand what Mr. McKissick is saying. What do you mean it's going to change? I got to do my investigation.
Oh, no, that's-
I got to do my, or that's how I would look at it as a lawyer.
that's not my point.
I need to know exactly, that's how I would feel about it. But I would rather know sooner, and so it's going to be somewhat incomplete. That may not be what you're saying, but that's the way my legal one.
Oh, of course, and by the way, that's so clear and reasonable in my opinion, there's my opinion. But when
I
you-
have a question too. We no longer have a quorum. Is that an issue for a study session?
Can't take action, and I don't know about you guys, I don't usually give you guys Brown Act advice, but you can take action, but you could let me bore you for the rest of the afternoon if you.
Okay, I'm fine with that. I'm not bored at all, but thank you.
Well, if this is board, I like it so far. Okay, now, what I'm asking is, that's all quite apparent, all right? But what I'm asking is when someone's brought in for the initial interview, all right, that's what I'm asking. Would the general nature of what's going on include, oh, by the way, our concern is about, and I know it can change. I know there can be additional charges. All kinds of things can happen in investigation. But in the initial interview, someone's there with the representative, would the person be told, oh, by the way, policy or procedure number or this law is at issue,
To the
right?
extent that they know at the time.
So in other words, I just heard, if I did, that insofar as the people doing the investigation know what policy or law is at issue, they should say so before the interview.
So that is what we could do with these options.
I don't know if the general nature includes that. It seems to me it would. That's general.
So part of the deficiency with the options, with legislation in general, is that we take a theory and a hypothetical situation, and then we build the language around it. So what I'm trying to do in tracking these options is say, you won't be caught unawares. I'm not going to hide the ball. That's what I'm trying to do. And to the extent that the information is known, it'll be shared. And I have to say, not hide the ball, because you don't always know until you've talked to the different witnesses. You can have someone say that employees were treated unfairly, or they were harassed, or they were belittled, and then someone else comes in and you find out that they have an age discrimination claim because you didn't talk to them, so you don't know that they were told they were teased or they were belittled based on that. And so that's what I mean by not hiding the ball. That investigator can't really clarify all of the charges until they've gone through in the interview of several witnesses, but they're going to have pieces. They have to have something to start with.
Exactly.
And they have to be able to match it to some timeline and some policy to start with. They could share that, but they may find out as they go along that there are other issues that they can't share because it's unknown to them, and they go, whoa, wait a minute, this is... And, that is part of the way that the investigative process works. You have to gather the information before you can really say, here are all the facts. And so we're trying to create that rolling knowledge share. It is imperfect. And part of your governance as board members and part of the shared governance is going to be working through that imperfect process of legislation. So let's go to, and as we go through these charts, I want to mention that some of the charts are, well, I'll talk about when I get there. You may want to, well, we'll go through C and D really quickly, and then we'll go to the charts. So you have C, and C is broader. C is the Skelly for everybody. So C is going to be a little bit more cost, have a little bit more of a cost impact. D goes to clear and convincing evidence. So D is the, and that's why I want to there was a Supreme Court case that we talked about when we did the due process review a while ago. Clear and convincing evidence is a higher legal standard, which means it takes more attorney time. So I want you guys to see that too, because I don't want there to be any factor, a cost factor that is left out, because you'll need to have all that information to weigh what you think is the best option. So I'm going to skip through the chart now. Okay, so here's option A. Uh-oh, we're still getting memo. Oh, here it is. Okay, there's memo. Okay. Okay, option A. All right, let me see if I could scoot this guy over. Okay, so let's go through the, okay. Okay, so you guys can see the whole stuff. So as I mentioned, A is the law as it is. So A is pretty straightforward. It kind of gives you what your due process is now. It doesn't have any cost impact. You're still doing what you normally do. And the right to a hearing is initiated if charges are filed. That's important because you don't always have a right to a hearing. You can have an investigation with no right to a hearing because it's found not to be substantiated. So there's option A, which we'll quickly go through. You have the first level trustee. There's no formal hearing. There's the name clearing hearing or name clearing opportunity, which could be submitting written materials or making a statement or something. No formal hearing. Volunteer, same thing. You know, because of the property rights that Chair Garrett was talking about. The hearings are attached under the law when there is a property interest. And so unless you're a permanent employee, at which a trustee isn't, or a volunteer, that's not going to happen, that's not going to be available. What you do have is the statute for all academic faculty, and that includes the adjunct, 87623, but that's only if you're going to be put on paid administrative leave, so that's only going to be in certain instances, and that is still limited coverage, really. So, but this is just laying out what the law is, as opposed to trying to address your query regarding how to provide more due process. Here I have, I estimated, 20 to 30 hours per week, but the cost of informal hearing could be more. So I'm trying to be conservative here, so it could be 20 to 30, but the conservative view is 40 to 50. And you'll see that you could get a bill that's between 14,000 to 17,500. And the disciplinary termination hearings would have a higher investigative cost. Those can cost as much as $200,000. You guys probably haven't had a whole lot of those, but they can be very, they can have a huge cost impact. And so and that's where you are now. And then when we go to the student, rather than sort of dissect Title IX, what I've done is write out how you have a multi-tiered discipline process. You have a very informal process where sometimes the students are brought in and they're talked to. You have sometimes where there's the charges brought against the student and there's a hearing process. I also remember that there was the issue regarding having the person who's implementing the discipline not be the person who's actually doing the hearing. So there's some issues that you may want to look at with your student disciplinary process, but rather than pull that apart right now, I want you guys to have an opportunity to think about this and see how you want to go, because I don't want to spend time rewriting something until the board's had a chance to digest and choose what you want to put the investment of time into. Permanent classified employee, again, that's a permanent employee that has a property interest. And so the collective bargaining is going to be what controls that process. There's the low estimate, 20 to 30. There's the conservative estimate of 40 to 50 hours. And so you have still about 14,000 to 17,500. Temporary classified employee is still a name clearing hearing because there's not a property interest. And so there's no formal hearing required under the Luby case. All right, then we'll go to B, which makes a change in the chart. And Graciela has shown me how to modify this a little bit. So I did it. I was paying attention. So remember, option B increases the notice options. It doesn't provide hearings where it's not required by law. So this is a baby step. And what Chairman Garrett had talked about is you're going to see in option C where you basically put the hearings across the board. So option B, you wouldn't have the hearing process for a trustee, but we also would have to have some sort of policies and procedures regarding investigations and alleged misconduct. Just as Mr. McKissick mentioned, you want to notify somebody of a policy or procedure, you want to have a process before you start out. So if we're going to build on this, we're going to have to put some time in the infrastructure. We're going to have to actually have a process. So that in order to go start with B and build on that, that would be one of the considerations. I didn't put a dollar amount by that because I think that we'd have to sort of frame it more to see, you might even somewhat borrow a process that's existing, but in order to have a hearing process, you're going to have an infrastructure with policies and procedures and that are set out for trustees as well. Same thing with volunteers. We haven't put that infrastructure together yet. Then we go to the adjunct faculty. That's an instance where there's not a property interest, so there's not a formal hearing requirement, but there is the 87-623, which requires the notice before administrative leave, paid leave. Permanent faculty, that's when you have the hearing right. And there's the lowball estimate and then the conservative estimate. So we're talking about, and then this one also B presumes the outside hearing officer. So what we're talking about is between 17,000 to 22,500. If we beef up the informal hearing process for the permanent employees, both faculty and classified. So that's the baby step that you have in B. There's also district time. Speaks somewhat to what Vice Chancellor LaGuardia was mentioning, that the district employee witnesses must spend time preparing for the hearing and attend the hearing. She was saying that there's staff time involved, and that if there's going to be an increase in the hearing process, then we have to consider what additional time that's going to take of staff. Immediate supervisor of accused must attend the hearing. HR staff must spend time preparing for the hearing and attend the hearing. And then, of course, the formal hearing for a permanent classified employee or permanent faculty member would be a more involved process. And that's when there's a lot more attorney dollars involved. Again, with the students, there's just a general discussion about the Title IX that has its own process with the State Chancellor's Office under Title V of the California Code of Regulations. And then the district may want to consider working on those student policies. It's been pointed out to us that there may be some aspects of that you want to revise. Permanent classified employee, there's the lowball estimate 20 to 30, the conservative 40 to 50 hours, and so you end up with the 17,000 to 22,500 plus staff time. If you are adding the outside hearing officer, that's a line item too, so you could see what that cost would be. And of course, you could also weigh what would the cost be if you had your own internal investigator or someone else to do the hearings as well. And the temporary classified employee, you have the academic faculty rights that are provided under the new statute, 87-623, but there's no formal hearing required other than the name clearing hearing, which could be something informal like it was in the Luby case, which was the officers they should have been called into the office before they were let go and told what the issues were and have an opportunity to respond. So that is B, the baby step, which basically increases the notice, but for the employees that are permanent employees that already have a statutory right to a hearing, or the bargain for rights, the bargain for discipline process. Now we go to option C, which is a bigger step. So we're adding hearing for everybody. And that is pursuant to a policy change. So again, in order to add a hearing for everybody, you need the infrastructure with policies regarding investigations that would affect trustees and volunteers, because we don't have that right now. And what we would then be doing is taking that component of the hearings where you get the notice with the general nature at the outset, and you do the informal hearing, presuming a hearing officer, which of course you could plug in or substitute with a different formula, but there's going to be a cost there with regard to the hearing. And so we have the informal hearing cost that's going to be duplicated through every segment of the district community. Does anyone have any questions about that aspect?
Well, I don't think that that's an option for us to grant hearings to people who don't have them. I mean, it's just financially not something that we could do. But to just inform people of more specifically, not general nature, but really specifically, you were talking to this, Alan, too, about exactly what is it that you know. Does that cost money?
I don't see how that would cost money unless there'd be a little bit of work that would have to go on in HR at the beginning to try and take the notes, look through the policies that have, instead of assigning it to the investigator, there would have to be the marshaling of some information and some review in order to make a cogent statement about what we know. So I would say that has to be costed out. I didn't actually write it that way, but I appreciate you bringing that up, because that's the beauty of having these line items segmented out, because that's a whole nother opportunity or another option that can be your option. We could plug these things in option B,
Right.
but there's not a hearing. What about just limited notice, quantify how much that costs and let us know? So, I mean, that is why you are sitting in that seat, because that's the governance role. I don't want to pay that. It hits the general fund. Can we do something in between? So I'll make a note and try and follow up and see what those costs would be so I can report back to you on that. But I haven't costed it out yet.
Okay, but I just don't think we could possibly expand hearings for everybody. But some things we can expand everybody.
So,
Modified B.
so here's another example of something that might not cost us anything, depending on the situation. You said that the education code requires that at least 2 business days before the employee is placed on involuntary paid administrative leave, the employee shall be notified in writing of the general nature, blah, blah, blah. Okay, so we could say the minimum is 2 business days. I'm thinking that most people would not be able to pull something together that fast, but we could say a week, 2 weeks, whatever, right? We could change the time.
Okay, so then what I'm hearing is that notice of charges within And then I'm going to put a blank there, so a reasonable time or something before, and that would be before,
We could stipulate longer than the minimum amount of 2 business days.
and that would be before the investigation starts, right?
Well, what I'm reading in this section, it's on page 6 of 7 of
The memo?
option C right now. Yeah, it's in the 4th column, and it just says, the employee shall be notified in writing of the general nature of the allegation or allegations of misconduct upon which the decision to place the employee on involuntary paid administrative leave is based.
Right, so that's a right that's for all academic faculty existing today, because.
Right.
And you're saying, so you'd want to have that, you'd frame the rights that all of the members of the community would have based upon what the legislature has described, but you'd change the amount of time for the district to sort of pull.
I'm asking if that's something the board can consider that would not necessarily add to the costs. It would extend a right, it would give them more time to respond.
Okay.
We could stipulate that, right, as a group?
So and that would be 2 days before, or a certain amount of time before the notice goes out, because there wouldn't be, the paid administrative leave is an existing right. So you mean before the person is called in for an interview? Is that, because that's the.
Yeah, that does relate, but of course, I heard you frame it in terms of the paid administrative leave situation.
You already have that.
Right.
So you don't want to.
So that's wasn't what I was referencing, but I think you raise a good point. I don't know.
I'm just talking about the things that we can do, because Ann was talking about how much certain things cost.
Oh, right. Oh, so.
So I'm just looking at what are the things that we could consider doing that would extend due process rights and extend time maybe for people to respond.
Okay, so then, so there would be a certain amount of time before the investigation begins, or before the person's called in for an investigation. Okay. I just wanted to frame it, because I think what Director DeMartini wanted was to cost out what it would cost to give everybody notice, and what you're suggesting is how much time, what it would cost to give everybody notice at a certain point, and I just want to make sure I get all that down so that when I reiterate it with the cost attached, that I answer both from both angles, or both lenses.
Well, I'm just saying that since you've attached the cost for hearings for people that are not initially entitled, I think we can stop with that, because it's financially not prudent for a trustee to approve that. So that is gone. So I want to focus on things that don't cost, or cost little.
And I might be being a bit, what do you call it, tedious, but I just want to make sure I report it back right, and my little legal brain is trying to make sure I get the exact wording. And so this is before the investigation starts, right? Is that?
Well, this particular one, I mean, I'd say across the board, but
Or just admin leave, or?
I was just focused on where my eye fell on the page.
Okay, all right, so then I get it. So before admin leave, but that, for the trustee and the.
I mean, that's been one of my concerns, that if a decision comes down and an employee has a right to appeal it, sometimes the time frame is so small, it's hard for them to consult anybody or get any help to respond, because they don't have much time. It's like all of a sudden there's a deadline.
So everybody, not just academic faculty, but everybody before admin leave.
Right.
And that means, so that would really be, not really the trustee, it would be the temporary employees, really.
Yeah.
And that really would be temporary classified, because the academic faculty already has it.
The adjuncts have it?
What for
Adjuncts.
academic faculty, how much time do they have to respond, to appeal a decision?
What type of decision are you talking? Where are we at?
Depends. I don't know. Give me examples.
So
I mean, obviously, if
we're talking
somebody's
about 5 different things at once.
right.
The very specific statute that Meredith has cited in the memo has to do with academic faculty only.
Right.
If they are being placed on paid administrative leave, they get 2 days' notice that we're going to take that action. And in that notice is a general nature statement about what happened. Now, this is new law, but I have to tell you, we don't take paid administrative leave lightly. And there is usually an exigent circumstance that here at the district for putting somebody out on paid administrative leave. That's huge. And it means that we need to remove them and get them out of the workplace as quickly and expeditiously as possible in order to protect the greater community. So giving a lot of notice may not be practical in this standpoint.
You were suggesting, or were you thinking?
No, no, I was saying, I think I said at one point, but I didn't repeat it, assuming there wasn't a dangerous situation or some sort of, yeah.
Okay, well, so then to the extent that you do put people on paid leave, so the extent that you do put people on paid leave, more notice is what you're saying.
Are you sure you're talking about paid leave? Aren't you talking about someone who decision's coming up and you want them to have more time to appeal the hearing decision? I mean, paid administrative leave is pretty much the prerogative of the district. I mean, the employee's getting paid. They don't appeal it.
All of the appeal rights are outlined in the collective bargaining agreements, and they have 10 days to respond when we're talking appeal rights.
Okay.
What I want to say is, I know that you want to make sure that the policy, or whatever is provided, is in concert with the collective bargaining agreement.
Correct.
So on that one, I would sort of hang back and let the negotiations lead.
Right.
But are adjuncts covered in the collective bargaining agreement? Or
Remember that adjuncts don't get hearings,
Right.
so the hearing, whatever the timeline, wouldn't apply to them.
okay,
So back to
then it's moot.
Trustee DiMartini's point, you want to provide the notice to everybody of the general nature, and how much would that cost?
Yes, and I like the way you put it better, that I don't like the general nature because that's pretty darn subjective. I liked that they'll know what you know, or
Okay.
that, I like that, where, because otherwise I think stuff will be withheld.
Yeah, you don't want people to hide the ball.
Right.
And that's the thing about legislation, you got to try and write it so that it's clear, and then you end up litigating it, which is what usually happens. But I'll make a note of that, and I'm going to struggle a little bit more.
I'm sorry I wasn't clear. I was trying to come up with a more general principle that when the law specifies a minimum amount of time for something that we're doing, we may want to have a little more time. In other words, if you were charged with something, how much time would you want to kind of get your act together and respond if you weren't a lawyer and you didn't know what you were doing?
And I would say on that one, the represented employees, we would follow what
The contract says, of course.
and then the ones that aren't represented would be,
That's where we have leeway, right?
yeah, if it's outlined in case law, or in the case of any employee that doesn't have the collective bargaining agreement already, would be a trustee, well, actually not an employee, a trustee, a volunteer, or temporary employee, whether faculty or classified. So on those, there'd be the notice that Trustee DiMartini mentioned, but then how much time before, or at what point would there be notice? And that's the question. Is it before the investigation starts, or is it before that person's interviewed? So that's the question.
Okay.
Interviewed would be my thing, because if the investigation starts and they didn't do anything wrong, then theoretically, yeah, so we shouldn't do it before the investigation starts. You should do it before the interview.
I want to just say that the views that we're expressing here are our own views, and not necessarily the views of the entire board, because we only have 3 out of
Absolutely.
7 people here, so.
I think I said that when you were out of the room, but
All I'm going to do with this is try and put a cost to it and then give it back so that you guys could deliberate on it. But it's not a policy draft or anything. It's just so that I know what components of the options provided do you think are worth looking into a little bit more? Because there's a cost attached to everything, and we don't want to overburden the district's general fund and take money away from, put more in the administrative operations of the district. We want to be able to provide the due process that you're considering more due process, but still with a mitigated or as little fiscal impact as possible. So what I'm just getting from trustees DeMartini and Beggs are, what do you want to hear more about so that you can know what the costs are to see if it's worthwhile pursuing in terms of policy?
I appreciate your thoroughness, and I'm getting an education on issues I haven't considered. But I'm sure some of the officers in the YFA have grappled with exactly these. So, thank you again. And not all boring, but my impression is that before the interview, if you say, all right, here's the particular policy, or here's the particular law, and here's what you allegedly did, which is something that occasioned the investigation, by the way, I can't see how that would cost anything.
What I want to do is not presume that I know all of your internal workings. That's why I just want to take the information, go back and look at it and find out before I say, here's the cost. If there's no cost, it'll come back, no cost. If there is
All right,
a cost, or if there's a due diligence requirement where the staff wants to be able to say, I need this much time to look at the policies or to go through some due diligence checkpoint, I want to make sure I give you that. Otherwise, I'm blindsiding you, and there's going to be a cost, and I didn't tell you.
Of course, but I perhaps that very limited issue could be addressed as to cost.
I mean, what we'll do is with the discussion of what the cost is, just like in the options, there would be a statement of what the tasks are too. But, I do construction law too. Everything has a line item, everything has a task, everything has a specific cost component. And so what I want to do is be as accurate and as transparent as possible and not make a presumption that it's not gonna take a lot of time or that it's gonna take a whole lot of time, because then I won't have helped you in weighing these factors. I'll go ahead and finish option C, although we are going to come up with a modified option that doesn't provide hearings where they're not statutorily or case law required. I understand that, but I just want to sort of go through the option C and then D. And so that means that for a trustee and a volunteer, neither of which there's a hearing required, there'd be an additional cost because we'd be providing hearings if we were to go with option C. And those costs would be, could be $17,000 to $22,500 plus the district staff time. Same thing with adjunct faculty. Then when we get to permanent faculty, we follow the collective bargaining agreement, and we would go with the discipline process that's in the agreement, because that's another, where I want to respect the process of the statute and I don't want to presume that, that I know better than the collective minds of the people that go through that process. And then we go to the student, again, if we're going to work on that, you guys would want to say, let's make some modifications with the understanding that Title IX is in the California Code of Regulations, and that there's a process with the State Chancellor's Office. So there's some things that are limited, but then your non-Title IX issues can be modified. There'd be some costs involved with that too, but I didn't start unraveling that knot. And not until you guys say you really want to delve into that, and then we could figure out if there's a way to do it bit by bit so that we could take it in chunks and know how much time you want to put into each piece. Permanent classified employees, again, covered by their collective bargaining agreement. And then the last one is the temporary classified employees, which don't presently have a hearing right. And by adding one would, of course, be adding cost. Now let's go to clear and convincing evidence standard.
Okay.
Has, since Title IX, the Dear Colleagues letter has been sort of put on the shelf, has any statement come out by saying, I forgot the term, but I know it's something plus a feather. Has that been changed?
The evidence standard?
The evidence standard?
No.
Because there's so many court cases now that are coming.
We have a state statute too that sets the standard of preponderance of evidence, preponderance of the evidence. So with Title IX, we still have the same process that is dictated through another reason why I haven't started to.
Okay, so then that's something we can't change.
Yeah, and I could come up with a bunch of options on that, but I think I'd be kind of, it would be theoretical, and
Yeah.
I at least owe you guys popcorn and a soda if I was to do that one. So I didn't do that one yet, because there's not too much we can do, honestly, on that one. So if we look at the clear and convincing evidence standard, this is a major jump in terms of the underlying work, because you're really going to a standard that's more or less used for where there's a right that is being, that could be surrendered. I'm going to try and find, I think I put the cases in here. I found some, if I didn't put it in here, I must have put it in the memo. Or I'll just sort of go with generally. But I did just look a little bit at the, I wanted to share a little bit of what the court says regarding the clear and convincing evidence standard. I'll go to the memo. I think I put, must have put it in these cases. Okay, so when the, as I mentioned before, the statute that we have regarding these informal hearings is preponderance of the evidence, and the courts, the California courts have said that issues of fact in civil cases are determined by preponderance of testimony. So there's an effort to preserve resources and have an evidentiary standard that is appropriate given the risk, the risk of what the person accused could lose. The preponderance of the evidence standard simply requires that the trier of fact believe that the existence of fact is more probable than its non-existence. That sounds like it's not a very strong standard, but generally when you look at the investigation reports, there has to be evidence that's more substantial than hearsay by one person. There has to be, generally in these investigations, you need to have more than just a little bit of one person said, maybe a couple of people said, or maybe a couple of people witnessed. And then proof by clear and convincing evidence is required where particularly important individual interests or rights are at stake, such as the termination of parental rights, involuntary commitment. So we're talking about liberty, we're talking about the separation from your children, or deportation. And so this is the way that the courts of our state look at the two evidentiary standards. So that is the backdrop that I've used for the review of the clear and convincing evidence standards for option D, because it is a higher evidentiary burden, and that would carry a higher cost, because it means instead of doing a witness interview, you might, that may be a half a day, you might need to spend more time, get more documents. You're going to need to put more time in to get the clear and convincing evidence standard, because it's supposed to be that it's a very glaring proof as opposed to more probable in its existence and non-existence.
I have a sort of theoretical question. So let's say we're having a determination on whether to fire a faculty member, okay, a full-time faculty member. And the preponderance of evidence is the higher standard? Or
Still use a preponderance of evidence standard, but it's not like the informal hearing, because they are more strict rules regarding, the informal hearing is sort of, you come in and everyone can produce their information, represented by an attorney, and you have the hearing officer there. If you're going to do a termination hearing, it's much more involved, because there's much more review and much more evidence, and it's a higher standard. And in the comparison of the charts, the termination hearings, I'll go back to, I think on, which one is this? On option C, one of the things that I wrote was that disciplinary termination hearings for permanent employees are quasi-judicial. So there's already, even though it's preponderance of evidence, there's a stricter requirement that how you conduct yourself, how you introduce the evidence.
so it is a higher standard. That's what I'm getting to.
Yeah, I mean, it's a higher standard. I'm using the word standard interchangeably, because in a judicial quasi-judicial environment, it's different than the informal hearing, which is a lot more familiar. So in other words, the process and the requirements of how you present your evidence and the weight of the evidence that you produce or that you have to produce is much more strict.
Okay, because what I'm trying to avoid is someone receiving an unfavorable decision from the district and then coming back and suing us. I want us to be diligent in the standard level that we use.
You have to be ready to go to arbitration when you're doing a termination hearing. I mean, Gina could speak to that, but you have to really dig deep and do your due diligence. And so there has to be a lot more review, a lot more time, effort. The permanent classified termination hearings, the industry norm is about $200,000 worth of legal time, whereas for these informal hearings, their low end is 20 to 30 or 40 to 50 at the most conservative. So there's
Okay.
a different level of due diligence that's required for
Okay,
two.
that's good.
And Gina, if you wanted to talk about, your current practices or the cost of the hearing, I'm just using an industry standard.
We actually haven't had one go all the way to termination in a really long time. They've usually settled, but that's what I've understood to be the industry standard, $200,000 to arbitration. Because when you go to arbitration, the standard doesn't change, but the rules of evidence change and how you introduce evidence. And so the arbitrator's like a judge, and they hear objections, and those go on the record. And you have to lay a foundation for all your evidence and say where it came from. And then that means you have to have witness who introduced that evidence. And so the methods by which the hearing unfolds are very formal. And that costs a lot of time and a lot of money to prepare to go to arbitration.
Does that?
Yeah, that's fine.
All right, so we were on option D.
You have to.
Thank you very much for your time. I'll go. Thank you for your time. I'll go through D really quickly because D is not just adding the hearing for everybody, it's adding the hearing at a higher standard, so the cost is pretty substantial.
Yeah, I don't think we really even need to go there because we can't possibly do that.
Yeah, that one's really going to be expensive, so we don't, we don't have to go through.
Yeah.
Because you guys have already given some guidance on what you
Okay.
can explore more. So I would ask then for sort of maybe some guidance on next steps.
Guidance on what?
Next steps.
What you would like.
Well, go ahead.
You go ahead first.
Well, I need a chance to read it, but just the overview, it looks to me that there is definitely not a lot that we can do without committing financial resources. I mean, at this point, and I need more time, but at this point, off the top of my head, I think the minimum that we can do that would be beneficial is for everyone in the YCCD community. The accused has the right to know what they're accused of. They need to know specifically what parts of policies they're accused of violating or what parts of law that they've been accused of violating. And they have the right to know the exact timing may be up in the air. I may not have an opinion on that, but they have the right to know the evidence against them. They have a right to see what they're being accused of instead of being blindsided in an interview where they have no prior knowledge.
And so then I will see what the due diligence, what the sort of minimum due diligence would be and what the hours involved in that would be.
That's for me. Okay, Leslie?
Well, I was going to say exactly what Ann said about I want time to read these carefully and sort of do the comparing and contrasting. I really appreciate that you laid all of this out for us. And to the extent that we can do things that transmit respect and fairness for our employees, and that don't cost a lot of money, but just show that we want to give people a fair shot at defending themselves and explaining their side of things. And I think that's a benefit to the district as a whole, because then when we do reach a decision, people go, yeah, but it was fair. And that's really important to me, that we make that clear, that what we're doing in the best way possible for everybody involved.
Okay, and so what I have is, so then it would be a no with a district no, because it's going to be incomplete at the outset.
And we need to make that clear too. Alan?
Yeah, in my discussions with trustees and so on, I've discussed this with, I think, every trustee but one, and we're still playing telephone tag to get together for a meeting, except a little bit over the phone. Having said that, I thought that was well expressed, and that's probably the heart of what the faculty's been advocating for. And an impartial trier of fact, but I'm not saying that can't be someone in-house, and I think there's a requirement that there be impartiality. Reasonably prompt decision, which I don't think is necessarily a change, but maybe making that specific in some way. But the right to receive a copy of the final report of the investigation, instead of a situation where suddenly the investigation stops and you're told, thanks for your time, never mind. But once there's been an investigation, giving the accused a report, this is how it turned out, right? I guess that would not preclude necessarily as more evidence came out or whatever, that the district continue with charges or even new charges or whatever. But simply once the investigation's done, when the accused is interviewed, right, and is told this is going on, and at some point it's over. Now, if the person's found to be liable for wrongdoing, it's not over necessarily. You've been talking about the complications that can ensue afterwards. I'm not addressing that. And just a report at some point is done, and it would not be acceptable anymore to simply say, all right, we're done. Thank you for your time, without any kind of report on findings.
I would support that too, so that if something has gone on for months and people have been stressed and worried, and then it's sort of like, oh, nothing came of it, I think we owe them more than nothing came of it. Dr. Holly?
Yeah, I want to second that. I had 2 charges of harassment made against me, and I kept continually asking Gina and the board, what am I accused of doing? Well, violating harassment. What did I do? I was never told. So I had to go get a lawyer, and another person had to get a lawyer with the same kind of vacuous claim made, and neither one of us were ever told. And then at the end we were told, well, since no punishments were meted out, you have no right to know. But if you're accused of something in an ordinary court, there's a kind of finality. And you're declared at least not guilty. You know what it is that you're not guilty of. You haven't been proven guilty of. So that's important. There's another thing too that, and it's important too that if you don't have rules like this, tyrannical people and unfair people can abuse its power to frighten people into submission. And that's, I believe, what was happening in this case. Okay, I don't want to go there, but the other thing too is that, but that is one of the reasons you want law to be fair. And I concur with what Beggs was, Trustee Beggs was saying, was that at least give us the appearance of fairness. And another thing I wanted to talk about a little bit is, do you know how much adjuncts make here? We teach at the top of our pay scale. This is relative. At the top of our pay scale, we get, for teaching a whole course, a whole semester long, we get $4,000. That's at the top of our pay scale. All right. So when you talk to me about the vast expense
Well, I've got to say, a lawyer knows what other lawyers charge. I, so that would suggest that the district would actually go through a process of presenting allegations against someone without having the due diligence of an attorney, which then would have an exposure to liability because you have not met the industry standard. I mean, the district would be going on a process that's not duplicated anywhere else, and when a reasonable process is reviewed, it's in the context of what the industry standard is, and that would mean the other community colleges, and they don't make allegations without legal review. So,
Or
you know,
shouldn't.
with all due respect, there is a standard that lawyers use and that's used in employee discipline. And one of the reasons why I've laid this stuff out is because it's expensive. And I don't want to suggest or present anything that isn't transparent in terms of cost. Now, I think it's high, which is why I'm being very, very measured and making a strong effort to write those costs out because I too have to look at policy and cost. And one of my good friends is a sociology professor that's an adjunct, and she tells me quite clearly that the pay for adjuncts is not very high. So I would only say that I'm trying not to hide the ball, and one can call any other community college or talk to any other VC of HR, and they'll tell you how much they get charged. I think it's a lot of money, but I wouldn't suggest that any district go that process or engage in that process and use a different standard than what's considered the industry standard, because then you could get sued. And once that happens, then you open your checkbook to your litigation costs. Plus, if you lose, you've got to pay. So, and then the other person's attorney's fees because they have an attorney. So,
Okay.
I would like to say that I think we've actually gone past our time limit. I would like to say, though, I would like you to look at what Dr. Holly said, that I would like to have everyone's a copy of the final decision, the
question about that. I was looking at the presentation. So, there's a process on one of the slides on page 3. And I just want to make sure I know what the process is presently so that I don't suggest, if I'm suggesting something that you already have, I need to be clear on that.
we need it, we may have it for some employees, but we need it for all.
So an investigation's concluded. If there are no findings and no wrongdoing and no discipline, the matter is closed and that report goes no further.
So I'd like to see if there are any costs in sharing that. It'd be nice to have reports saying that you did nothing wrong. I think the person should get it.
So what we're talking about is the
Closure of an investigation.
Closure of an investigation, providing a report to an accused who's been exonerated.
so that'd be like an administrative closure report. And do you do those now, or do you?
In Title IX cases, we write the administrative closure letter saying that there was nothing wrong, but not in employee discipline.
Okay, so I wanted to make sure I'm clearly framing this because I don't want to be off. I don't want to cost out something that's different than what you already do. I need to know the difference between them so I could.
Right.
Okay, so the request is for an administrative closure report at the conclusion of each investigation, whether it goes.
Regardless of the outcome.
Sound like that's what you had?
Well, I don't know the terminology, but I think that a person has been accused, and if they need a report at the end of the investigation. This is what you did wrong, this is your discipline, or this is, we researched this, you didn't do anything wrong. But I thought that
We
if you
couldn't
didn't do
prove it.
anything wrong, you weren't going to know that you were accused of something.
I'm sorry, if you get notice before the interview and then there is an investigation and it is unsubstantiated.
Okay, then they should get that report. That's what I'm saying, that should be a right for everyone in the YCCD community, whether you have a collective bargaining agreement or not.
Okay, so I've got the administrative closure report, and I'm just using sort of industry terminology.
Okay, fine.
And then the modified be the notice of charges, knowing what the district knows and what that cost would be. So I've got two things. 2 things to report back on.
Okay, thank you.
May
And
I-
then,
Oh, I'm sorry, please go ahead.
as Ann and I said, we both want to read this, and can we talk to Henry and just email you our other,
Or actually through Henry, I'm
through Henry? Okay,
sort of a stickler for,
that's fine. I just didn't know what the procedure was after we read
Yeah,
through this.
just as a backstory, sometimes if I work with the board and I get different emails that I have to read each one, then you get the little .25 or .35. So if you go through Henry, you'll be concise.
That's great, that's great.
I want to bring up something that hasn't been discussed much here, but I did see several references to the right to representation. This did come up during the board policy meeting, the right to representation. Now, let's just specify for the moment, full-time faculty for the moment, right? So the right to representation, but there's been some confusion and some disagreement over the participation of the representative and whether the representative can play an active part in the discussion. I know there's already a prohibition of disruption. I know that, right? But at one extreme, which we've definitely seen, a representative from the union being told, you may not say anything. You may not say anything. You can call the person out for a conference, but you may not say anything and else. And so I believe you said something before, and here's where it's a little dangerous because you know what you said and so on. But of course, that the advocate could advocate. That's why they're there. So clarifying, right? Or if not the legal requirement, which there's been some dispute about, but maybe good practice of can the representative speak to the situation and take an active part in the interview. And so that's my request. I'm not a trustee, but I do know that's been an ongoing.
Well, and I requested earlier that, you know, we have this thing that says we don't have to notify him. Well, let's notify him. You know, which is what you're saying there too.
So I want to stay clear of the things that are bargained for the represented employees, because that is a process that I would have to
Okay.
engage myself in to understand to write. Then you're paying 2 lawyers, and I don't want to overlay myself on something that,
Well, then do it for those who don't have a collective bargaining agreement.
By the way, I'm not talking about a bargaining issue. I'm talking more of a legal issue or a good process issue. I'm not talking about what the contract says about what your representative can say in the meeting, right? I believe those are called, I'm going to say it wrong, Weinberger rights, right?
well, actually, if the discipline process is laid out in the collective bargaining agreement and I would be clarifying, then I would be doing something that you'd probably do in your,
It's not. Now, I have Article 39, all that right here, but just the general proposition, and for more than just faculties who are in a union, right?
I could do it for those who aren't represented, but for those who are represented, you'd want your representative to make clarifications regarding what's in the agreement. I mean, I would be overlaying, and I'd have to work with lawyers who are doing the negotiations, which would be double lawyering.
Right. When we talked about this at a policy and procedure committee meeting, I believe you referred to it as that your representative does not have to be a potted plant.
The potted plant. I remember that Mr. McKissick had that quote about the.
Oh, okay, forgive me.
But what I could do is for those who aren't represented, so that I'm not like stepping into a realm that's already covered with.
Just clarify that the attorney or person.
But what we do in depositions, and what we do when you have you're represented by counsel, is you have a process where you handle the evaluation of whether there was an appropriate objection or whether instructing the witness not to answer was appropriate. So we'd have to have a dispute resolution process. So that would mean stating the policy and then the dispute resolution process. So you'd want to have some internal process for who's going to review whether it's a reasonable question or not. So I would say the two have to come hand in hand, because one thing we do with legislation and policy is we presume what happens if it's not followed, or what happens if there's a dispute or an interpretation difference. So you would want, if you're going to have the policy, you'd want a dispute resolution or conflict resolution process too, which would mean it would go to, you'd appeal it to someone else to make a determination as to whether or not if there was someone that said there was interruption or there was an unfair, the conduct was not appropriate, who would make the determination?
If we back away to sort of a higher altitude view, I liked what Darren said about sort of a document of guiding principles. And it seems like that would fit in the guiding principles that, you know, your representative should be allowed to represent.
And I would add that, of course, I see your position and I see the good sense in not having policy that contradicts the contract or vice versa, of course.
It's just a matter of, I'm just trying to stay in my lane,
Of course.
but
Of course.
Vice Chair Beggs, if I may make an observation. We have spent the last 2.5 hours looking at the rights and making sure that we fairly treat people accused of wrongdoing. We have not mentioned once the people that might be the victim of that wrongdoing. And retaliation comes in very subtle forms. Hypothetical, a student makes a complaint against a teacher, no wrongdoing is found, and the full report is sent to that teacher, including who the student was making the accusations. We owe our allegiance also to the potential victims of wrongdoing, not only those people accused of it, and oftentimes they go overlooked. I suspect if we make it far too open and far too easy to find out, we will have the incidence of reported wrongdoing will go down for fear of retaliation. I've seen it in other places where that fear has made it, hey, it's a he said, she said, I'm not going to report it. And we see it on the news all of the time. I think in any practice that we propose, we should make sure that we equally look after the rights of the people who are the potential victims. Thank you.
I agree.
I think that's really reasonable. Glad you brought it up. And I want to say that again and again, the faculty have stated the same sentiments. I think a report, I'm not sure full report, I'm not speaking for or against it, but just something in writing saying these are the, you know, basically you were, this was the policy procedure in question, there was a hearing, there was no findings of wrongdoing. That would be an absolute minimum, I think. And I'm not saying there should or shouldn't be more, but I agree. Naming names for someone that vulnerable is, the union, for example, the YFA, has never asked for that.
Yes. Yes.
Sarah, I want you to provide my office a list of specific violations because we have been steadfast in providing the date and the nature and scope. So you are telling the trustees that we have violated the agreement, and I would like you to provide us the very specific list of when that happened. We don't need to do it here because we've taken up way too much time, but if you could send us an email, I know you still have access to email, and let us know exactly what you allege we violated. So it's the pending case before the PERB already, so it doesn't really belong here then. It's a pending case. There's nothing, there's no action that anybody here can take. You have alleged a violation. We say we haven't, and now it is up for the completely neutral Public Employment Relations Board to decide that case. It's out of our hands.
Well, I'd like to thank you for your time here today, and we will go through Henry and continue to work on this. I'm the vice chair, so that's why I get to close the meeting. So do I have to borrow a gavel?
I just want to express my thanks to you, Meredith, for coming here today and giving us an in-depth look into this issue. And we have divergence of opinion today, but that is good. And I certainly hope that we can move from divergence to convergence as you prepare summaries and revisions that have been mentioned earlier. And hopefully the trustees who were not able to make it here today would be able to review that, and then we can continue the conversation, and hopefully we can make a decision down the road. And I know regardless of whatever decision we make, the trustees would have put in a lot of time to carefully consider all the pros and cons, the ramification, and then decide what is best for the district, what is best for the employees, what's best for our students, because ultimately we're here to serve students. So I want to thank you again for taking the time to come and be with us today.
Thank you very much, all of you, for giving me the opportunity to talk to you about something that's so important to all of you and important to our community.
Thank you very much. So our next meeting is on at 5:30 on July 11th. And if there are no further comments, I will adjourn this meeting. Can I do that?
30.
What?
Correction, 3:30?
Oh, I read it 5:30. I'm sorry. 3:30. Open session at 5:30. Got it. Thank you.
And Meredith, for the record, I don't think any of that was boring.
Yes.